So arbitration, just in its simplest form, is where in the contract you agree instead of going to court, you will go to arbitration. Okay, so there's no judge, there's no jury, there is an arbitrator. Sometimes there's three arbitrators. And typically things happen quicker, although not always from court, but typically quicker than going to trial. And there's a different pay structure. So when we go to court, whoever files the case pays a filing fee, and that's all you pay. In other words, you don't pay for the salary of the judge. I mean, that's done through taxes. You don't pay for the jury. Again, that's done through taxes. And that's it. I mean, it might be a month-long trial, a 3-month-long trial, or a one-day trial. It's the same cost. In arbitration, it's different. You're paying that arbitrator or the arbitrators per hour. Sometimes that's $400 an hour, $500, $700, $800 an hour. And so who pays that? Well, typically in the types of things we're discussing on this channel, consumer type transactions, normally the creditor, in other words, the company that you did the loan with or you bought the car from, they will say, hey, maybe you pay $150, $200, $350 filing fee, and then everything else they will pay. Okay. So it raises some interesting questions. What if you get sued by a creditor? I've got a question here about, if a debt buyer is suing me, but the original creditor, I agreed to arbitration with them, can I force that debt buyer who's suing me into arbitration? And is that a good thing? And what happens if they don't show up? Well, generally you can, but you have to actually read the arbitration agreement itself to know exactly what it says. So does it specifically say that the arbitration is just between you and the original creditor? Or does it say something like, if you sue us or we sue you, and then it defines we as the original creditor and anybody working for us, anybody collecting for us, anybody that we sell or transfer, then that would cover the debt buyer if the debt buyer truly bought it. So you have to read the terms, and there's a place, typically it's on the CFPB website. I don't think it's been moved lately, where you can find basically all the terms and conditions of contracts and of credit card contracts. And so I would suggest going there. You'd say, well, I have a Capital One or Synchrony Bank or whatever it is, and find the terms and conditions, and you'll find the arbitration language. And then with that language, you can see, okay, does it look like it applies? Usually it will say that all claims have to be arbitrated, but if they're suing you for small claims or some equivalent, then it does not have to be arbitrated, but usually it gives you permission to arbitrate if you want. Now, what would happen is if you insisted on that, you would be moved from court to arbitration. And again, you have no judge, you have an arbitrator, which is usually a lawyer, sometimes a retired judge. And then the creditor would have to pay a pretty good amount, maybe the entirety of it. So, one strategy is to say, well, hey, I'm being sued for $2,000, but if the arbitration is $2,500 that they have to pay to get started, are they really going to do that? Well, from just an economic standpoint, it would not make sense. Sometimes they'll do it anyway, just to kind of send a message to say, hey, look, don't try and compel arbitration and think we're just going to go away. Okay. So it certainly is a strategy. Now, if they don't show up in arbitration, it'd be the same as in court. They'll end up losing that case. And then that can be very beneficial when it comes to credit reporting and things of that nature. If you're being sued, it can be a strategy. You really need to know, how good is the court that you've been sued in? What do the judges do? What are the rules where you are? And then see, does it make sense to force the other side into arbitration? And look, it's the same thing, but kind of reversed. When we sue debt collectors or we sue Capital One or Synchrony Bank or whoever it is, they have to decide if the arbitration agreement gives them permission to arbitrate, do they force us to arbitrate? And sometimes they do. Sometimes they say, hey, John, you've got to go to arbitration. And then we may argue about, well, are we going to what's called JAMS, JAMS, or are we going to AAA, which is American Arbitration Association? And, we'll go back and forth and who's paying what. And then we may agree to it, or we may say, no, we're going to fight you on this. But same thing, whoever is being sued can decide, do I want to force this into arbitration? And whoever's doing the suing, if the arbitration agreement allows it, you can certainly push to file that directly in arbitration. Typically, it's faster. Typically, the rules of evidence are, I think how to say this, are just sort of more open, okay? Because arbitrators, about the only way they can be reversed by a judge is just not considering evidence. There's really no appeal based on, well, I think the arbitrator reached the wrong conclusion. Judges aren't interested in reviewing arbitrators for that. But if they just say, I'm not going to hear any evidence on something, that gives an opportunity to maybe get them reversed. So most arbitrators are pretty free in terms of like, hey, bring in all the evidence you want, and then I'll evaluate it. I'll give it the weight that it deserves. Okay. So it's a little bit sort of looser rules than being, for example, in federal court or even in state court. And that can be to your advantage or maybe to your disadvantage. So just keep that in mind. Arbitration, we do arbitrations. Obviously, we do court cases. And one thing with COVID, it's just really slowed down jury trials. I mean, we had a jury trial we were supposed to be trying in the middle of March of 2020. And that's right when the shutdown happened. And I mean, we're looking probably this in federal court, I don't know, August, September of this year on a case we were supposed to try in March of last year. So, it's slowed down with arbitration. That tends to be a little bit easier. It's typically all done by Zoom. And instead of having 6 jurors or 12 jurors, you have typically one arbitrator. So that makes it a little bit quicker. So just let me know if you have any follow-up questions on arbitration.